Hello, and welcome to another Help for Homeowners webinar session. I am Clemente Mejia, and I supervise the Foreclosure Prevention Unit at the Los Angeles County Department of Consumer and Business Affairs. This week, we'll be discussing the California Foreclosure Process and foreclosure protections. Next slide. The County of Los Angeles Department of Consumer and Business Affairs has been serving the Los Angeles community and consumers since 1976. Our mission is to promote a fair and vibrant marketplace. We serve consumers, businesses, and communities through education, advocacy, and complaint resolution. Next slide. Since the onset of the pandemic, millions of Americans have been able to suspend mortgage payments through a CARES forbearance plan. The Federal Housing Finance Agency, along with the Federal Housing Administration, Veteran Affairs, and the USDA, or United States Department of Agriculture, continue to extend the moratorium on foreclosures and evictions over the year, and these protections are set to expire on July 31st. Homeowners who currently have a forbearance plan will continue to forbear payments until the end of their term. However, others have to explore post-forbearance options offered by their lender or servicer. Navigating the process during a time of crisis may be a daunting task. The DCBA, along with local housing counseling agencies, are working to proactively outreach and inform homeowners about available resources and where they can go to receive legitimate help. Today, we have two foreclosure prevention experts who will tell us more about the California foreclosure process and foreclosure prevention options and where homeowners can get free, reliable help. Before I turn it over to the presenters, just a reminder to our participants, please keep your mics muted and use the chat box to submit your questions. Sam?
Thank you, Clemente. My name is Samuel Lakeen. I work for the Department of Consumer Affairs for the County of Los Angeles. I am a senior foreclosure prevention counselor. I'm doing this for a little while, and I'd like to talk to you about some information that is sort of going to be very vital concerning foreclosure and as the moratorium's end. So what is foreclosure? A lot of misconceptions come up. We do get a lot of confusion around this idea. But foreclosure, basically, it's the legal process that's used by lenders to recover the balance of the loan when a property owner fails to meet the obligations of the loan. Next slide. Now, in California, there are two different types of foreclosures that can occur. There's what's called a judicial foreclosure, and then there's a non-judicial foreclosure. Now, typically, a judicial foreclosure will involve a mortgage, and a mortgage is going to be an agreement between a borrower and a lender only. Now, when a mortgage intends to foreclose, when a borrower, like I said, fails to meet the obligations of that loan, the lender is going to have to sue in court in order to begin that process of foreclosure. Now, a non-judicial foreclosure is going to involve what's called a deed of trust, which is actually more common. Now, a deed of trust is going to involve a borrower, a lender, and a third party called a trustee. Now, when the deed of trust is actually made, the borrower is going to convey the power to sell, so to speak, to the trustee. Essentially, when the borrower defaults on the loan, the lender is going to request that the trustee begins the process of foreclosure. Now, the foreclosure trustee sale, is going to actually conduct a public auction, and that in order to recover the balance of the loan, and that's not going to require a court or a judge to decide whether or not it's going to be, it's going to go through. Now, in California, like I mentioned before, both of them can occur. But generally, it's going to be considered a non-judicial state. Next slide. Now, the California foreclosure process is actually sort of short, but again, it is a process. The first step is going to be what's called a notice of default being filed with the county recorder's office. Now, that initial notice, when it's recorded, is going to give the borrower essentially 90 days to come up with an alternative or a solution before step 2 begins. Now that again is the first step in the process, and it's not the end of the foreclosure process. The second step is going to be what's called a notice of trustee sale. Now, the notice of trustee sale is a document that does have to be filed or recorded with the county recorder's office. And that is a little more important because it does in fact set an auction date. It's going to let you know that within or at the end of 20 days, they are going to sell the property at auction to recover the balance of the loan to make them whole again. Now, the next step essentially would be an auction. Four things usually, well, mostly are going to come out of this. An auction can be postponed. Maybe somebody is engaging with their lender. The lender decides to push off the auction to decide if they're going to look at options that are available to them. An auction can be canceled. We go to the very bottom. It could be canceled because maybe the borrower has come up with the money to pay off the loan. Maybe they've already entered into an agreement and they're going to cancel it. Now, the middle options here, sold to a bank and sold to a third party, that would be if the auction actually goes through. Now, when it says sold to the bank, essentially, a trustee sale is going to ask for the minimum bid, which is going to be everything the lender owes, to recover their losses. If nobody bids on it, the bank or the lender is going to have to take it back on their books. Usually that's called an REO, or real estate owned property. Or it could be sold to a third party. Maybe somebody bids on the property, maybe there's a bidding war, whatever that might be. The third party would basically pay the money, recover the loan would be wiped out, and they would gain ownership of the property. Those two options, either way, would still trigger what's called a trustee's deed upon sale. Now, that trustee's deed upon sale is going to trigger the transfer of ownership over to the winning bidder, whether it be the lender or the servicer, or it be a third party. Now, that document doesn't in fact have to be recorded, and it will show who the new lender is, what they purchased the property for, and when it was, when they obtained ownership. Next slide. Now, notice of default, a couple of things here. Essentially, the lender is going to record an ND, what it's commonly called, or notice of default, after a borrower fails to meet the terms of their loan. There are other terms of the loan beyond making your monthly mortgage payment. Some loans have different caveats. Maybe you have, most loans are going to require that a property owner holds enough property insurance against the asset. Property taxes have to be paid on time. Properties have to be kept in good, I guess you could say in decent standing, meaning the property can't go into disrepair. Those different things can also trigger a notice of default, meaning the beginning of the foreclosure. Now, again, this is in fact the start of the foreclosure process. It's not the end. And I know a lot of people, when they get this information that they're entering the foreclosure process, it can be a little jarring, but it is the beginning, okay? At this point, this is what we typically tell people to do: is apply for foreclosure prevention options. Open up a conversation with your lender, begin looking at why you entered the foreclosure process, and start figuring out what's available to you. Next slide. Now, this is a copy of a very common notice of default. When you get one of these in the mail, that's really going to be something that you want to look at. You want to make sure that this document has your name, your property address. You want to kind of verify what it is that they're claiming that you owe as of what date. Really look it over and make sure that if you receive something like this, that it's yours. Next slide. Now, the notice of sale is typically called a notice of trustee sale. The lender is going to record it 3 months typically after a notice of default. Now, the reason I say typically is because that's the minimum standard. The law says that lender has 90 days to wait after the notice of default is recorded before they can record a notice of trustee sale, basically moving the process along. Sometimes they do wait a little longer. It's really up to them. The important part about this document, though, it does in fact set the auction date. It'll set a date. The document will say 21 days after this is recorded, we are going to sell your property for the minimum balance owed to the highest bidder. During this time, the opportunity to apply for foreclosure prevention options is limited. And this is more due to the idea that you're very close to the date. There are rules and sort of opportunities for the lender to just decide that they want to be done with it and move forward with the sale. However, it's not necessarily always impossible to work out some sort of agreement. Again, we still always recommend, even if this is on the table, to open up the lines of communication with the lender and discuss what might be available. Next slide. Now, this is a copy of a document that's typically an average notice of trustee sale document. It's going to show a couple of important things. It's going to show the address, it's going to show the borrower, it's going to show the total amount due to recover the loan, and then most importantly, it's going to show the sale date. Now, these documents, when you look through them, it's going to also include what's called a trustee sale line, meaning a telephone number. Sometimes they'll do a telephone number and they'll add on an online tool where you can look up the most up-to-date information. And then it's going to give you your trustee sale case number. At any time during this process, you're supposed to be able to call that telephone number, provide your trustee sale line number, and get information as to whether or not the status of the sale is going to go through, whether it's going to be postponed, canceled, or whether it's just done altogether. Next slide. Now, if in fact the document or the trustee sale does go through and it does sell to a third party or goes back to the bank, the trustee's deed upon sale is going to be the next document that needs to be recorded. Now, this document, in fact, does transfer the property to the winning bidder, meaning the previous property owner, it's over. They're not going to be the owner. Okay. Now, by default, if nothing happens, the lender, like I mentioned, would be the winning bidder if nobody else bids on it. Counseling to move forward is sort of, it goes along with the idea of making sure that the trustee's deed upon sale is not necessarily accurate, but that you use that information to help you decide what your next steps might be. Usually during this process, somebody might engage in a conversation with the new owner to discuss, exit options. It could be discussing, essentially, what do you do next? Okay, next slide. We'll go over that in a second. Now, this again is a copy of a typical trustee's deed upon sale. It's not filled in, but what it will mention is what the property did in fact sell for, who the actual new owner is, which is very important when you talk about, different parties coming and claiming that they're the owner. You'll have it in writing, and then it's going to also show the address, the name, the borrower, and different things that are going to be important as you move forward out of this process. Next slide. Now, after the foreclosure, a previous borrower is going to get what's called a notice to vacate. Now, if the occupant of the property is the actual borrower of the loan, they're only required by law to receive a 3-day notice to vacate. At the end of that 3-day notice, the eviction process can begin. Now, tenants, should they be bona fide tenants, could potentially receive a longer notice before eviction. It really depends. There could be perhaps a means test to make sure that the tenant is what's called a bona fide tenant. But I mean, that might be a conversation for a different day. But if you are receiving notices to vacate, it's highly recommended that you at least contact our office so we can look at what you have and advise you otherwise. Now, normally when you receive a notice to vacate, a cash for keys negotiation is usually what we recommend. Cash for keys is a common industry term that's used when these types of notices are received. You're going to want to engage with the new owner to discuss the terms of you vacating the property. Now, it's not necessarily a mandatory rule that new owners are required to offer previous occupants, maybe a couple of extra months to leave, or maybe, a little bit of money to leave. But the idea is really there to make sure that both parties kind of exit, the occupants exit gracefully, and the new owner is ensured the idea that the property is sort of taken care of during this time. Next slide. Now, a lot of people do tell us, how do I know if I'm actually going to be in the foreclosure process? My lender might say I'm up to date on my payments, or maybe I can't get through to my lender. Well, in the County of Los Angeles, the Homeowner Notification Program was actually established in 1996 in order to alert homeowners of newly recorded documents. Now, when a document is recorded, whether it changes title or whether a loan is taken out in the form of a grant deed, a quitclaim deed, or a deed of trust, copies of these documents are required to be mailed to those parties interested, whether it be the actual property address, or a mailing address within 30 days when those documents are recorded. The purpose of this is to let somebody know that something has in fact been recorded against a property they may be interested in, and you want to take a look at it. Okay, next slide. Now, the enhanced homeowner notification program came about when SB 62 expanded that program. So in addition to a grant deed, a quitclaim deed, and a deed of trust, a notice of default and a notice of trustee sale were actually included to be required to be mailed out to property owners who might be interested in that property that it was recorded against. This really, the idea here is so if a property does begin to enter foreclosure and maybe a person doesn't have direct contact or much direct contact with their lender, they're going to get something in the mail from the county letting them know that this process has started. SB 827 reduced the time to mail a notice. Originally, it was 20 days. Now it's required to be mailed out within 14 days, essentially attempting to cut down the time that a property owner might lose should they not understand that they're beginning this process. AB 1106 extended the program for another 10 years, so essentially making sure that this information went out to interested parties or people who may be affected in the future. Next slide. Now, the Department of Consumer and Business Affairs is actually set up to provide what's called foreclosure prevention services. Now, the main goal with the unit, the foreclosure prevention unit, is to assist homeowners in actually preventing or avoiding the foreclosure of their property. I can't stress enough that every situation, in fact, is different. It's difficult to sort of put everything in one single box. I mean, we do our best, but the advantage of working with our department is individual attention is actually provided because these requests for assistance are assigned to one counselor, one foreclosure prevention counselor, who's going to go through your exact situation, discuss your options, reach out to the lender on your behalf, and talk about what is actually going to be available to you at the end of the day. Opening a dialogue with the lender is one of the most important things that we recommend, even if you don't go through a HUD certified counselor or maybe our department. Talking with your lender is actually one of the best things that you can do if you're in a situation like that. Next slide. So now we're going to get into the idea of the CARES Act and the protections that are available to certain individuals and certain property owners. I'm going to hand that off to one of my colleagues. Her name is Ani Dafshin. Ani, go ahead.
Thank you. So under the CARES Act, servicers are required to grant a forbearance to all borrowers with federally backed loans if they are experiencing a financial hardship due to the COVID-19 national emergency. The CARES Act only covers federally backed loans and not non-federally backed loans. Hardships include but are not limited to unemployment, reduction in regular work hours, or the illness of a borrower, co-borrower, or dependent family member. No documentation of hardship is required when applying for the CARES Act. Next slide, please. So all borrowers with federally backed loans that are current or less than 30 days delinquent will be automatically granted up to 6 months of initial forbearance. In general, servicers are offering a forbearance plan of 3 months in increments. Borrowers can receive extensions of up to 12 months in increments. So in total, borrowers can receive an 18-month forbearance plan. The post-forbearance options will be different if a borrower was more than 30 days delinquent before the COVID-19 hardship period. Mortgage forbearance terms will depend on the type of loan the owner or investor requires in your mortgage loan and your servicer. It is also important to contact your servicer directly to discuss your situation with your lender, and the Department of Consumer and Business Affairs Foreclosure Prevention Unit can assist you in contacting your borrower. Next slide, please. So as of June 30, 2021, the CARES Act was supposed to end, but it has been extended to the end of July. If the extension does not continue after July and the foreclosure moratorium expires, property owners will need assistance. After the moratorium expires, foreclosures can legally proceed and property owners may not have the funds necessary to become current. Next slide, please. Or I'm sorry, can we actually go back one slide? Thank you. So I also wanted to discuss that during this time, vulnerable property owners should be aware of scammers. You may be approached by individuals or companies that are guaranteeing that they can stop your foreclosure. However, foreclosure prevention cannot be guaranteed by anyone but your lender or your servicer. So now can we go on to the next slide? So AB 3088 is a fairly new law that took effect on September 1 of 2020, providing additional protections to certain renters, small landlords, and some homeowners who are unable to pay their rent or mortgage after being negatively affected by the pandemic. Next slide, please. Prior to AB 3088, non-federal mortgages were not required to provide assistance to a property owner who was experiencing a financial hardship due to the pandemic, as only federally backed mortgages were covered under the CARES Act. This bill outlines how a lender is going to respond to a request for assistance concerning borrowers or property owners negatively affected by COVID-19. And we'll go over that in the next few slides. Okay. AB 3088 applies to the first lien and a forbearance review is required. The homeowner had to have been current on their mortgage as of February 2020 in order to qualify. And unlike the CARES Act, homeowners must provide proof of financial hardship that was caused by the pandemic. If the borrower does not qualify, the lender must specify the reason for disqualification, and the decision must come from the lender within 21 days. They must also include specific ways to amend the request for forbearance. Next slide, please. The homeowner also has a right to appeal the lender's decision. If they choose to appeal, the lender must provide a response to the appeal within 5 days. If the forbearance is accepted, the lender must reach out to the homeowner prior to the end of their forbearance plan and let them know what options they have after their forbearance is over. Governor Gavin Newsom also signed in AB 832, which extended the effective time period for non-federally backed mortgages to provide a written notice if their forbearance was denied. It must state the steps necessary to cure the defect, and this provision was originally set to expire in September of this year. However, with AB 832, it was extended until December 31, 2021. Next slide, please. So now I will be discussing the Los Angeles County Mortgage Relief Fund that the Department of Consumer and Business Affairs has partnered with the Neighborhood Housing Services of Los Angeles County, or NHSLA, and its network of counselors to provide foreclosure prevention counseling services to property owners of Los Angeles County. Eligible property owners may qualify for up to $20,000 to pay for missed mortgage payments, and the program began on April 12, 2021. Next slide, please. So to be considered for the Los Angeles County Mortgage Relief Fund, you must meet the following criteria. Your property must be owner occupied, meaning you must live on the property and it should be located within the County of Los Angeles. Property owners must demonstrate a COVID-19 related hardship. Property owners with one unit will qualify if they have a loan balance of up to $726,525. If the property owners have 2 to 4 units, then they will qualify with a loan of up to $1 million. Because each homeowner's individual situation is so different, we recommend you call or apply online to further discuss qualifying for this financial assistance. On the next slide, we have information to contact the Neighborhood Housing Services of Los Angeles County at their phone number or their website as listed on the slide. Next slide, please. So the California Business Consumer Service and Housing Agency has rent relief options for both landlords and renters. Landlords who have one or more eligible renter can apply to get reimbursed for 100% as of June 28, 2021 of each eligible renter's unpaid rent between April 1 and August 31. Prior to June 28th of this year, they could only be reimbursed for up to 80%, and it was set to expire in March of this year. Requirements include, but are not limited to, all payments received being used to satisfy the renter's unpaid rent for the periods between April 1 and August 31. And renters must take the steps to verify that meet the eligibility requirements and sign the application prior to receiving any funds. Next slide, please. Renters will be considered eligible if they have qualified for unemployment benefits or experienced a reduction in household income, incurred significant costs, or experienced other financial hardships due to COVID-19, and or have demonstrated a risk of experiencing homelessness or housing instability. Eligible renters whose landlords choose not to participate in the program will receive assistance provided directly to them. Next slide, please. For more information or to apply for the COVID-19 relief as a landlord or a tenant, you may contact the California Business Consumer Services and Housing Agency by phone or visit their website to apply online. Next slide, please. The American Rescue Plan, which was administered by the U.S. Treasury, was created to build an equitable economic recovery by providing working families a $1,400 check per person. This was better known as a stimulus check. It was created with the intention of helping Americans stay in their homes by providing emergency aid to cover back rent and bills, and help struggling homeowners catch up with their mortgage payments and utility costs through the Homeowners Assistance Fund. And it is set to provide additional funding for families and individuals who are recovering from or are at risk of homelessness. Next slide, please. The California Mortgage Relief was a part of the California Housing Finance Agency, and it was established to mitigate financial hardships after January 21, 2020, associated with the coronavirus pandemic by providing funds to eligible property owners. Next slide, please. The goal was to prevent homeowners from mortgage delinquencies and defaults, foreclosures, loss of utilities or home energy services, and displacements of homeowners experiencing financial hardship. Next slide, please. For more information or to apply for the California Mortgage Relief Fund, you can contact the California Housing Finance Agency at their phone number or visit their website. And next slide, please. For more information regarding foreclosure prevention, rent stabilization, or any information regarding the presentation today, you may contact the Department of Consumer and Business Affairs at our general line or visit our website. Next slide, please. We will now be taking questions from.
Okay, thank you, Ani. So once again, if you have a question, please enter it in the chat box. We'll go ahead and answer them as in the order that we received them. So we're going to go ahead and start answering some of the questions we received. The first question, what programs are available for Van Nuys? Van Nuys is not eligible for the $20,000 grant. So I believe this question is referring to the county's mortgage relief program, and that's correct. LA City property owners are not eligible for this fund because the city of Los Angeles has their own rent relief program. So what that means is tenants would need to apply for this for this money. Now, if you're a property owner and you don't have tenants, so this is assistance that you need for your own mortgage. At this time, like Ani stated, the California Mortgage Relief Program may be an option. That program was created and funded by the American Rescue Plan. However, it's not available yet. The California Housing Finance Agency is still putting together the requirements, and I believe right now they're going through a public comment session about the program they're about to roll out. So that may be an option for the Van Nuys property owners or any property owner in the city of Los Angeles. So again, if you have a tenant, you could contact the LA City Housing Department and apply through there. Or if not, you may want to just keep a close eye on the California Housing Finance Agency's program, which is funded by the American Rescue Plan. Next question. If the lender postponed the sale to review the borrower's application, but they did not qualify for assistance, does the lender need to record a new notice? So I'll let Sam answer this question.
Thank you, Clem. Hi, so the lender would not, in fact, be required to record a new notice. The lender would actually just need to let you know and update you by the trustee sale line that the sale has been postponed and give you the information for the new sale date.
That's correct. And you could actually find the contact information for the trustee company. So that's the company that's handling the foreclosure action in one of the notices that you received in the mail. So whether it be the notice of default or the notice of sale, they should have a phone number or a web page where you could access and check the sale date status. It should also provide the minimum bid as well, and the location of the auction. So that information can be found in one of those two documents. Good question. Next one. If the home is sold for more than I owe, what happens to the extra money? Okay, so I'll go ahead and let Sam answer that again.
I'm sorry, Clem, can you repeat the question?
So I believe the question is about excess proceeds. So if the house is sold for more than what they owe on the loan, what happens to the excess proceeds?
Okay, so when there are excess proceeds, if a property is in fact sold for more than the lien or for more than it was to satisfy the lien, those excess proceeds are going to be transferred in the care of the trustee. Now, the trustee is required to send out notices to all potential claimants of that money. Now, it could be a second lien, it could be a homeowners association, it could be the actual owner. Now, what they're going to do, they're going to take those forms out, they're going to review them, and they're either going to decide to distribute based on their decision, the rightful owner of the proceeds, or essentially they could, hold on to them or send them to the court to let somebody else decide.
Okay, thank you, Sam. Again, so if you have any questions, please go ahead and enter them in the chat box. We do have a few minutes left, so we still have time to answer your questions. I do also want to mention something about the post forbearance plan options. So we hear that property owners may obtain up to 18 months of deferment. But once those 18 months come up or it's expired, property owners would then have to explore post forbearance options. So if you have a Fannie Mae or Freddie Mac loan, it's our understanding that they're allowing property owners to defer that money to the end of the loan and basically pick up where they left off. So continue making their monthly payments. Now, the issue is that they don't have the income to sustain those monthly payments. then most likely what they'll have to do is submit an application to be reviewed for a loan modification. So a loan modification is basically modifying the terms of your loan, which could be reducing the interest rate, extending the term of the loan. So in other words, extending it from 30 years to possibly 40 years. They could also defer a portion of the principal to the end of the loan. And in some very, very small cases, and this is what we saw with the Making Home Affordable program during the Great Recession, they may even forgive a portion of the principal. But again, these are not typical options. And so these are really one-on-one type issues where people need to be reviewed. Also, it depends on the investor's guidelines. So when we're talking about investors, so it could be Fannie Mae or Freddie Mac. Some situations, your loan could be bundled into one of these securitizations. So it could be a group of investors that owns your loan. So there's going to be a bunch of things that need to be reviewed in order to see where you qualify or where you fall. But again, best thing to do is reach out as soon as you can to explore your options. So it could be directly through us. You could contact us. Again, our services are free, and we can have one of our counselors work with your lender to see what's available. Also, we urge you that if you want to try with a HUD-approved counseling agency, you could go ahead and reach out to them, and they basically provide the same service. But the best case too is also reaching out to your lender directly. And this time around, we noticed that homeowners were quick to do that. If we compare it to the Great Recession, it seems that homeowners this time around were better educated, and they reached out to the lenders when they when they learned or identified an issue with their finances and contacted them right away. So that's actually the best thing to do, is just to stay in contact with your lender, like Sam suggested. So I don't see any other questions in the chat box. So what we'll do is just wrap up the presentation. But again, if there's any questions or if you need additional assistance, I believe our contact information was on the presentation. So the presentation will be available on our YouTube page, and the slides can be accessed at this link here. So the dcba.lacounty.gov /foreclosure prevention. So you can get a copy of the slides there. Thank you, Sam and Ani, for your thorough presentation. And if you or someone you know is facing foreclosure, please remember that the Department of Consumer and Business Affairs is here to help. Our services are free, confidential, and our well-trained staff can work with you and your lender to explore all your options to save your home. Thank you and have a good evening.